Study Session 12 Labor Legislature in Nigeria. Introduction. In this lecture, we shall discuss issues relating to labor legislation. To this end, we shall begin by examining the sources of the Nigerian labor law. We shall also examine who a worker is, the various ways of terminating employment contracts, and avenues available to a worker who is wrongfully dismissed to seek redress. Objectives. At the end of this lecture, you should be able to 1. Discuss who a worker is. 2. Discuss the contract of employment. 3. Explain the various ways by which the contract of employment can be terminated. And 4. Highlight the avenues available for redressing wrongful dismissal. Pre-test. 1. Critically discuss who a worker is. 2. Discuss the contract of employment. 3. Explain briefly the various ways by which the contract of employment can be terminated. 4. Discuss the avenues available for dealing with wrongful dismissal. Nigeria's legal system is based on the English common law, which continues to apply except to the extent it has been modified by some statutes. In relation to the termination of employment, the most important statutes are the Labour Act 1974, also known as the Labour Decree 1974 as amended, and the Trade Disputes Act 1976, TDA. Scope of legislation. All labor law statutes in Nigeria, including the Labour Act and the Trade Disputes Act, apply only to those persons considered employees at common law, that is, those employed under a contract of service rather than a contract for service. In addition, both acts apply only to those employees who are workers. The Labour Act defines a worker as any person who has entered into a contract of service with an employer, whether the contract is for manual or clerical work, or is expressed or implied, or oral or written, Section 90 of the Labour Act. The courts have interpreted this definition to apply only to manual or clerical workers. The Labour Act definition also excludes 1. Any person not employed for the purpose of the employer's business, such as domestic staff. 2. Persons exercising administrative, executive, technical, or professional functions. 3. Members of the employer's family, also excluded by Section 21 of the Labour Act. 4. Representatives, agents, and commercial travelers, to the extent that their work is carried out outside the employer's permanent workplace. 5. Home workers. 6. Any persons employed at sea or on an aeroplane who are governed by specific legislation. 7. In addition, members of the armed forces and police are excluded from the Labour Act. The definition of worker in the Trade Disputes Act mirrors the Labour Act's definition, except that it is expressly extended to workers other than manual or clerical workers and to apprentices. Furthermore, the exceptions listed above do not apply Section 47. However, again, members of the armed forces and police are excluded from the Trade Disputes Act, Section 48. Contract of employment. Contracts of employment may be either contract for an indefinite period or for a fixed term or fixed amount of work. The common law position that contracts for a fixed term or fixed amount of work expire according to their terms is codified in Section 9, subsection 7A of the Labour Act, and this rule has not been modified by statute, nor is there any further statutory regulation of fixed-term contracts. Probationary periods are possible, although, as the statutes do not exclude probationary employees from their ambit, the statutory notice periods below also apply to probationary employees. The term casual worker has no legal significance in Nigeria. Termination of contract of employment. The termination of contract of employment, other than at the employer's initiative, is largely governed by common law. Contracts of employment may be terminated, other than at the employer's initiative, by 1. Mutual agreement, either by an agreement as to the term of the contract or an agreement that employment should end. In this case, the parties to an employment contract can at any time, by mutual agreement, either in accordance with the terms of the contract or otherwise, bring the employment to an end. And this is true whether the contract is of a definite or an indefinite duration. Number 2, frustration. Any contract of employment may be brought to an end by frustration. When frustration occurs, it kills the contract itself and discharges both parties automatically. A contract of employment will be brought to an end by frustration where changes in the circumstances of the employment either render further performance of the contract impossible, or where the obligations undertaken by the parties under the contract have become radically different. Events such as death of either party to a contract, illness of an employee, outbreak of war, change in the law, or even imprisonment of an employee may bring about frustration. Number 3, the employee resigning by giving the requisite notice. There is no doubt that either party to a contract of employment has a common right to bring the contract to an end by giving notice of this intention to the other party. However, to do this, appropriate notice must be given. Number 4, summary dismissal. This refers to where employee persists in refusing to obey his employer's orders. In this case, the employer will be justified in dismissing him. Therefore, after a refusal on the part of the employee to perform his work, the employer is not bound to keep him as a burdensome and useless employee. However, where incompetence is alleged, the onus is on the employer not only to prove the incompetence, but also that it justifies summary dismissal. Therefore, where an employer alleges incompetence on the part of the employee, but he is unable to prove it, the dismissal is held to be wrongful. Besides, under the general law of contract, only conduct or breach which amounts to a repudiation of contract will justify the innocent party in opting to bring the contract to an end. A single act of misconduct may justify summary dismissal. Misconduct, whether cumulative or single, is viewed in the same way. The real difficulty is in determining whether misconduct shows an intention to disregard an essential condition of the employment. Not every misconduct amounts to a repudiatory misconduct, although there is no fixed rule of law which defines the degree of misconduct which amounts to repudiation. Where misconduct is committed outside working hours, it will justify dismissal only when it is proved to be harmful to the employer's business or reflects on the employee's capacity to perform his duties in accordance with the contractual terms expressed or implied. Even when summary dismissal is held justified, it cannot be made to take the retrospective effect from the date of the misconduct held to justify the dismissal. Section 10 of the Labour Act codifies the common law position that an employee's contract of employment may not be transferred from one employer to another without the employee's consent, and in addition requires authorization of any transfer of employment by a government labour officer, who may also require a medical examination. Dismissal. There is no general statutory principle against unfair dismissal in Nigeria, and the law of dismissal is largely governed by the common law as affected by the Labour Act. However, a dismissal may constitute a trade dispute under the Trade Disputes Act, in which case the worker concerned may bring a claim to the National Industrial Court (NIC) under that act. Notably, while it is far from clear from the statutory definition of trade dispute in the TDA, that is, any dispute between employers and workers, which is connected with the employment or non-employment of any person, that claims relating to dismissals are covered by the Act. In practice, the NIC has exercised jurisdiction over dismissal claims. There is, however, little statutory guidance as to the standard the NIC is to apply in adjudicating trade disputes involving a dismissal, its remedial jurisdiction simply being to make amends and settle trade disputes. Section 15, subsection 1, paragraph A of the Trade Disputes Act. There are specific statutory prohibitions against dismissal on the grounds of union membership and activity. See Section 9, subsection 6b of the Labour Act. And pregnancy and taking maternity leave. Section 53, subsection 4, Labour Act. In addition, the common law has developed the concept of a constructive dismissal, that is, behavior by the employer which is intolerable and which forces the employee to resign, and which is deemed to be a dismissal. And as part of the common law, this concept is part of Nigerian law. The Labour Act, Section 11, subsection 5, expressly retains the common law right of an employer to summarily dismiss an employee for serious misconduct. The Labour Act also retains the employer's ability to dismiss on the grounds of redundancy, Section 20, although this section also introduces certain procedural requirements for redundancies. See below. Redundancy is defined by Section 20, subsection 2 of the Labour Act to be an involuntary and permanent loss of employment caused by an excess of manpower. Notice and prior procedural safeguards. Section 11 of the Labour Act sets out statutory minimum notice periods as follows. 1. For less than 3 months of service, 1 day. 2. For 3 months to 2 years of service, 1 week. 3. For 2 to 5 years of service, 2 weeks. And 4. For more than 5 years of service, 1 month. The above periods are statutory minimal, which can be improved upon by collective agreements or contracts of employment. Payments in lieu of notice are permissible, and either party may waive the right to notice. See Section 11, subsection 6, Labour Act. For dismissals for misconduct, the common law rules that employers who, with full knowledge of the employee's conduct, condone such conducts, cannot thereafter rely on the conduct to justify a summary dismissal. However, the common law rule also applies that misconduct discovered after dismissal may justify the dismissal. There are no statutory requirements as to procedure for dismissals for misconduct, although a breach of any contractual procedure may constitute a breach of contract, leading to an award of damages. Likewise, there are no statutory procedural requirements for dismissals on the ground of unsatisfactory performance. For dismissals on the grounds of redundancy, Section 20 sets out the following procedural requirements. 1. The employer is to inform the trade union or workers' representative of the reasons for and anticipated extent of the redundancies. 2. The principle of last in, first out is to be applied, subject to factors of merit, including skill, ability, and reliability. And 3. The employer is to use his or her best endeavors to negotiate redundancy payments. Severance pay. There is no general statutory severance pay, although there is provision for the Minister of Labour to enact regulations providing for severance pay to redundant workers pursuant to Section 20, subsection 2 of the Labour Act. In addition, the NIC has on occasions awarded severance pay as additional compensation to unfairly dismissed workers. Avenue for redress. Claims for wrongful dismissal or breach of contract may be brought before the civil courts, although such claims are limited to damages for the equivalent amount that the employer would have earned during the notice period, and generally exclude reinstatement and damages for injured feelings. In addition, as discussed above, a dismissed employee may submit a trade dispute to the NIC, and the NIC has a wide discretion as to remedies, including reinstatement. The resolution process for trade disputes can also include conciliation provided by the government. Study session summary. In this lecture, we have discussed issues relating to labor legislation in Nigeria. Specifically, the lecture dealt with the sources of Nigerian labor law, contract of employment, termination of contract of employment, as well as issues relating to notice and prior procedural safeguards, severance pay, and avenues for seeking redress. It identified ways through which the contract of employment may be terminated, such as mutual agreement, frustration, by resigning after giving appropriate notice, and by summary dismissal. That ends study session 12. Thank you for listening.